with my client. So at this time, our hope is to set this case for trial. However, schedule it for a final pretrial as well in hopes of resolving that matter at the final pretrial.
Okay. Ms. McClure, do you have a sense of how much trial time we're going to need for this case?
Yes, Your Honor. I'm hoping just a day. I'm hoping to get a one-day trial date in June with a final pretrial in May. But in the meantime, if we could have a pretrial also in either February or March.
Okay, is that agreeable with you, Mr. DeMattis?
Yes, Your Honor.
And I think in addition to that, before that February or March pretrial, I believe Mr. DeMattis had wanted a bench conference with Your Honor.
That's correct, Your Honor.
Okay. So Ms. Clark, we'll need a one-day jury trial date in June.
Tuesday, June 10th at 9 a.m.
That works for the people.
As well for the defense, Your Honor.
Okay, so let's do a final pretrial then. How about May 28th? So May 28th at 8:15, we can do that by Zoom.
That works.
And then, I'm sorry, Mr. DeMattis, that date work for you?
Yes, it does, Your Honor.
And Ms. McClure, I'm sorry, you said you wanted an earlier pretrial date, but I have forgotten when you said you wanted that.
Yeah, just whatever you have available, either in February or March after a bench conference with Your Honor.
Okay. Let's go with March 5th at 8:15. And then Ms. Clark, can you find maybe just a 30 minutes, a sufficient amount of time for a bench conference?
Yeah, I would say 15, 20 minutes at the most.
Okay. So Ms. Clark, can you find us 15 minutes or a half hour for a bench conference sometime before March 5th?
Thursday, February 20th at 1:30.
At what time, I'm sorry?
At 1:30.
That works. I have a bench trial with you, Judge, but I assume we'll take a break from the bench trial to do the bench conference.
That works for the defense as well, Your Honor.
Okay, we can do that. And I'm sorry, Ms. Clark, that was February what day?
February 20th.
20th, okay. Okay, so I will put together a scheduling order and send that out to the attorneys. Is there anything else we need to address with the case today?
For the record, as of that pretrial on March 5th, I will withdraw the current offer that any offers on the case.
Okay, anything else?
And Your Honor, if I may, that March 5th date, if Mr. Samuelson decides to avail himself of the offer, can that be conducted on Zoom or do we need to be in person?
That can be on Zoom.
Okay, thank you.
Okay, anything else for today in this case then?
No, thank you.
Nothing from the defense, Your Honor. Thank you very much.
Okay, thank you then. You can go ahead and log out. Mr. Samuelson, you're all set. You can log out.
Thank you.
Ms. Underwood, are you ready to proceed with Mr. Delaney?
I am, Your Honor.
This is file 24-21828-FH, People versus Ryan Robert Delaney. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. Can I first have the attorneys place their appearance on the record, beginning with Ms. Williams?
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Rhonda Underwood on behalf of Mr. Delaney.
Okay, and Ms. Underwood, where do we stand with Mr. Delaney's case today?
Your Honor, Mr. Delaney had a hiccup in his payments. However, he made a payment yesterday for, I believe the total that I saw on the screenshot of the receipt was $871, Your Honor. And I've spoken with the Attorney General's office, and I believe under those circumstances, they would have no problem with a 60-day adjournment for Mr. Delaney to continue making payments.
Okay, is that correct, Ms. Williams?
Yes, he was to make the payments before the hearing. I have not seen proof of that, but that was the agreement. If he made payments before the next hearing, we would adjourn out 60 to 90 days.
Okay, I will adjourn this then to April 2nd at 8:15 a.m.
Thank you, Your Honor.
April 2nd?
Correct.
Thank you, Your Honor. And
Ms.
I
Underwood,
would be happy to do the stipulation in order with Ms. Williams' permission.
Yes.
Okay. Thanks then. We're all set. Mr. Delaney, your next date is April 2nd at 8:15 a.m. You'll use all the same Zoom information that you used to log in today.
Okay, thank you.
Okay, Mr. Amadeo, I believe we have Ms. Frank here. Do you need to speak to her?
No, Your Honor, I'm ready to go. Thank you.
Okay. This is file 23-21418-FH, People versus Carly Lynn Frank. We are here today for a pretrial in this case. We are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194. On behalf of Ms. Frank, we appear via Zoom and consent to such. Ms. Frank, please state your name.
Hi, Frank.
Okay, Mr. Amadeo, where are we with Ms. Frank's case today?
Your Honor, I did contact your staff yesterday. She has not replied to me in 2 weeks. She sent me a text this morning saying that her phone did not work. I've got too much respect for your court and the people to keep playing these games. I would ask to withdraw, but I don't know what happens if I do make that request because I'm already on as a conflict as a favor to the public defender's office. If you want to set a trial, you're certainly the boss, but I've had no communication with her, and I've contacted her at least a dozen times the last 2 weeks.
Your Honor, okay, my phone was stolen actually, and I've had double pneumonia. I've been hospitalized in the last month twice. That is the only reason, and I've contacted him also. There was 4 different times that I contacted the office, but I cannot get through for some reason. None of the emails to go through, and none of my text messages. I was just looking at them. I have 17 different text messages I cannot get to go through. Everybody else perfectly fine. Cannot get them to go through his. But I just got back from the hospital 3 days ago. I've had double pneumonia for the last 7 weeks, and that is the only reason that I have not been making contact. I do want to go to trial, and I'm sorry for interrupting, but it's not that I'm not trying to contact him. I literally can't. And my mom just bought me a new phone 2 days ago.
Judge, I'm not going to hold your court up. I know you're busy. I think you know me. I've tried desperately to reach out to Ms. Frank numerous times. If you're willing to grant another adjournment, she wants to go to trial, I'll prep it, but I've made countless efforts. I even sent her a text and I copied the prosecutor on it to tell her that she's not replying back to me. I'm not sure what to do to help this woman, Your Honor.
I tried to send screenshots to you this morning showing that I'm trying to reply to you. I left voicemails at your office. The contact says you have a Zoom list 2 weeks ago.
All right, I don't have time for the two of you to have a debate about who's done what to try to contact who. This is a case that was bound over to this court in 2023. It is 576 days old. So we're done with, I tried to call in that kind of conversation. At some point in that period of time, these things needed to have happened. So I'm going to set another pretrial that's going to be conducted in person so that Mr. Amadeo and Ms. Frank can be in the same room and talk to one another and figure out where this is going to go. And at that pretrial, I will be setting the case for trial.
Understood, Judge.
How about February 12th at 8:15?
I'll be there. Thank you, Your Honor.
All right, Ms. Frank, you need to be here at the courthouse in the courtroom on February 12th at 8:15 a.m.
Okay, Your Honor. Thank you.
Have a good day, Judge. Thanks.
Ms. Hang on, Mr. Amadeo. Ms. McClure, is there anything else that we need to address with the case today?
No, nothing on behalf of the people. Thank you.
Okay. Thank you, then, Mr. Amadeo. Ms. Frank, you can log out.
Thank you.
Are you ready with Ms. Gessman?
Yes.
Okay, she's here.
Yes, she's here.
Okay, can we bring in Ms. Gessman? Other table. I need to get the other table to the defense table. Thank you. This is file 24-21976-FH, People versus Joanna Isabel Gessman. We are here today for a pretrial conference. In this case, we are proceeding today in person, partially in person, partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Evie McClure, may I have the people?
Nancy Eaton Gordon assigned special public defender for Ms. Gessman.
John Glazer, I'm just here to help in hopefully resolve this. I'm not representing Mr.
Okay. Ms. Eaton Gordon, then where do we stand with Ms. Gessman's case?
Well, we still have a plea offer pending with the prosecutor's office. We would like to try to get Ms. Gessman out today. She is, to our understanding, being held just simply for the contempt for failure to appear. According to the records we have, she's picked up on either October 9th or 10th of 24. So her time served has ended on that. We are hoping to get her released so we can get her to CMH for services. I've been speaking extensively with Todd Wright over at CMH, as well as Cora Gibson from our mental health court, trying to get Ms. Gessman to services so she can get and maintain the medication she needs, so we can get her to a state where we think she can accept the plea. The issue is CMH is not able really to provide her services while in jail. We need to get her out so we can have her report in there for services, even if Your Honor wants to make it some kind of condition of release, so they can start providing services within 14 days of her assessment. That's one of the rules for their funding and their regulations. And the issue is they really can't assess her at the jail and have her be released after the 14 days. They have to start all over again because they can't provide services unless they start within that 14-day time frame. I've also been in contact with Share the Warmth. Ms. Gessman is unfortunately homeless and doesn't really have any other place to rely on or places to stay. But Share the Warmth indicated as long as a bed was available, that there's nothing preventing her from staying there. They've given me further instruction that we know she's to be released. I can contact them on her behalf and confirm that a bed or a bunk is available. And then she would have to report into them in the afternoon, the normal times that they have people report in to stay at the shelter. Right now, the goal would be ultimately to get her out and get her connected with services at CMH so she can get to long-term housing. She had started the process before she was picked up on this contempt to get an application processed with housing help. That process had started but was not completed when she was picked up for this charge, but it can be restarted as long as the housing help is able to access funds. And I know they're currently on a hold for at least temporarily because it's executive order that was passed, but they think that's going to be cleared up here soon. So we're hoping to get her out, connected to services, have her report directly to CMH, and get it to where we can get her back on track and hopefully then have more serious of a conversation with the very generous plea offer that Ms. McClure's office has put forward.
Okay, Ms. McClure, any response you want to make to that request?
Yes, Judge, and I think it's important you know the procedural history here. Obviously, after this case was charged, she was referred to the Forensic Center for a competency evaluation. She was finally deemed competent as of August 22nd, 2024. When she was deemed competent at that point, she was released from the Forensic Center out into the community, where she was given directions on what to do with community mental health and how to be compliant with them. Within that month, she stopped taking her medication as directed. She failed to be in contact with community mental health and ultimately failed to appear in front of this court. And again, that was within a month of that. As of October 2nd, 2024, this court issued a bench warrant and she was arrested within that month. And since then, which would have been the end of October, she's been in jail while we've been trying to resolve the case. I don't know if she's maintained competency or not while in the jail. I don't know that any of us would know other than a doctor. That being said, if she's able to talk with her attorneys about the case, I think the court can make a determination that she is able to participate in her defense enough. My position would be that without a resolution in this case, that she remain in the jail, because otherwise we're going to go back into the same cycle that we were in August, and we're just never going to get anywhere with the case. If she is unable to participate in her defense at this time, then she probably needs to be re-referred to the forensic center for a competency evaluation and treatment, and again, needs to stay in the jail for that to occur. And any referral to the competency center does toll the timing on the case. But again, this is a case that's been out there since September 2022. Without some movement on the case, we're just going to get back in the same cycle and we're never going to get a resolution. Part of the resolution is mental health treatment through mental health court and district court. So again, I think that's another strong point to have a resolution before we release her for community mental health evaluation and treatment. Because that would be part of the resolution in the case. Obviously, I can't force them to have her plea or can't force her to plea, but that is my position, that she remain where she is or referred unless there's a resolution in the case.
Your Honor, if I could speak. I think it's quite clear that Ms. Eaton and myself, when we talked to her, this woman's not competent to enter a plea or do anything of that sort. So basically what we're doing is keeping her in jail, because she can't enter a plea. She needs some mental health treatment. If she gets released, and we've talked to the mental health court, Ms. Eaton's also talked to many members of the Department of Human Services for mental health treatment. They simply can't do it while she's in jail. I think if she gets out and gets her treatment, goes to her appointments, that she'll probably be able to enter a plea fairly shortly, 30, 60 days.
May I say something real quick, if I'm allowed to talk with
Ms.
permission?
Yesman, you're represented by attorneys. So
I'm sorry.
the attorneys are the ones.
I just didn't know if he was saying the right thing or not. I didn't know what the whole law of there's.
But I think it's very apparent she's not competent to enter a plea. And if we send her back up she went up, Ms. Eaton tells me she went up for 4 evaluations. Incompetent, and then found competent. She's schizophrenic and what else? Bipolar. And she's off her meds at this point. I don't know when she last took her meds, but it's simply a situation where we're housing somebody that has a mental health issue. We can enter the plea and get her into court, but not until she's at least competent enough to know what's going on. And she doesn't know what's going on at this point.
And unfortunately, Your Honor, if I may speak, this is a case where someone in CMH and other parts of our court has said, it's sad, but this is a fall through the cracks case because our community doesn't have the specialized inpatient treatment facilities that might help someone like Ms. Gessman, that if we could get her into a place like that, but we simply don't have it. So we're stuck in a catch-22. And I feel Mr. Glazier's summation is accurate. She's at a point where we don't think capacity is going to help. I don't feel confident she can knowingly and understandingly give a plea to anything at this moment. So if the court wishes to have her reassessed, that's going to be the court's purview, obviously, but she served extensive time on this underlying simple contempt, not on anything else related to her charge. And until and unless we can get her, attempt to get her to CMH and get her to services, I don't think that's going to change in the jail.
This is an unfortunate catch-22 kind of situation where a person has been referred for an evaluation on competency and found to be legally competent, but still has some obvious mental health issues that need to be addressed, which cannot at this time be addressed because she is incarcerated. The reason for the incarceration situation is the court's obvious and I think well-founded concern that Ms. Gessman may not appear at future court hearings because she has not appeared in the past. But that obviously is due to the mental health situation, which can't be treated because she's incarcerated. Looking at this case, she's charged with 1 count of uttering and publishing and 1 count of identity theft. The information does include a second offense, habitual offender second offense notice. It appears she has a prior conviction for possession of a controlled substance less than 25 grams. I haven't seen anything in the file that I can pick out while I've skimmed through it here this morning that she has an assaultive history. Appears that there are arrangements as best we can make them given her financial situation to have her housed at Share the Warmth. So I am willing at this point to grant Ms. Gessman a bond so that she can obtain mental health treatment she needs. Can be a PR bond with the conditions that she report to Darren Coast, often as Mr. Coast requires. I'm going to start that at 3 times per week, but if things go well and Mr. Coast decides that a lower amount is okay, then that fine. You must not use alcohol, marijuana, or any illegal controlled substance. You must participate in a substance abuse testing or monitoring program. Stay living at Share the Warmth. And you must participate in a mental health assessment through community mental health and follow any treatment plan required or suggested by community mental health. And Ms. Gessman, you need to come over to the courthouse as soon as you're released. You need to go from the jail to the courthouse and see Mr. Coast up here on the 3rd floor. We'll cross the hall into the clerk's office. When you get here, ask for Mr. Coast. They'll come and get him and bring him out to you.
Your Honor, if I may.
Just one second. I'm also going to set this for a pretrial on February 12th at 8:15. Obviously, one of the purposes of that pretrial is going to be to check in and see that Ms. Gessman is complying with all conditions of her bond.
That it, Jared?
I think Ms. Eaton Gordon had something she wanted to address before we conclude.
Yes, if I may, do we have an idea when she may be released from the jail so I can make calls to share the warmth and to CMH to try to let them know and get prepared as they can be for.
We will likely have the paperwork prepared and sent over to the jail sometime this morning. For that, I don't really have a sense to be able to tell you.
That's okay. Today, just letting them know that it might be as early as today is sufficient. Thank you.
Could I make a brief record in the case?
Go ahead.
Just wanted to make sure it was on the record that Miss Gessman was previously deemed competent because she had received that inpatient treatment through the forensic center, and upon her release, willfully made herself incompetent by not complying with their treatment orders.
All right, Mr. Coast, do you need any information at this point?
I don't, Judge. I'll talk to her more when she gets out and up on the third floor.
Mr. Coase, I'm gonna come over and talk to you too, but I'm gonna talk to her first and I'll be over in about 5 or 10 minutes.
Sounds good, Judge.
All right, thanks.
Okay, thank you. Then we can be adjourned in this matter.
Thank you, Your Honor. Thank you. Thank you, Dee Dee. Thank you.
Thank you.
Yep. Persevere.
Mr. Casper, your client's here with you.
They are, Your Honor, both.
Okay, so let's start with Mr. Burke. This is file 24-22059-FH, People versus Douglas Stephen Burke. We are here today for a pretrial hearing in this case. We are proceeding today partially in person and partially by video conference. Can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, we have the people.
Bert Castleberry on behalf of the defendant.
Okay, Mr. Casper, where do we stand with Mr. Burke's case today?
Your Honor, we have a plea offer from the prosecutor's office. We also had a Cobb's evaluation with the court. I believe we are here to plead today.
Okay, Ms. McClure, is that all accurate?
Yes, Your Honor.
All right, Mr. Casper, you want to state the terms of the plea agreement for the record, and then I'll ask Ms. McClure to confirm.
One moment.
We can do it the other way around if you don't have it in front of you right now.
It doesn't matter. I do have it, but I have to pull it up to read it. Now, the offer was to dismiss plea to count 2 felonious assault, dismiss count 1, which was assault, great bodily harm, less than murder. Any jail time would be deferred is the recommendation from the county prosecutor's office, and the court did a Cobb's agreement with myself that the court would honor any jail time deferred.
Okay, Ms. McClure, is that a complete and accurate statement of plea agreement?
It is. The only addition I would have is that restitution in the case is 17,345, and that was payable to the victim in the case through insurance already. But that is the amount of loss in this case.
But our plea offer is that restitution, we would still be entitled to a restitution hearing if that became an issue.
Yes, on the plea agreement, it states restitution to be determined by the court. I just wanted to acknowledge that that was the amount.
Thank you.
Okay. Mr. Burke, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Douglas Stephen Burke, is that correct?
Yes, I am.
Mr. Burke, you've heard what your attorney and the prosecuting attorney have said today. Is it your intention to plead guilty today to count 2, assault with a dangerous weapon or felonious assault?
Yes,
You understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine.
yes,
Are you satisfied with Mr. Castleberry and the advice that he's given?
yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Ms. McCoy?
That's
Yes.
correct.
Mr. Castleberry,
That is correct.
is that also your understanding, Mr. Burke?
Yes,
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have at trial. I'm going to explain those to you now to make sure that you understand them.
Okay.
You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Burke, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
yes, I do.
You also understand that any appeal of the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, I do.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, I do not.
Do you understand that you're giving those rights up?
I do.
How do you wish to plead to the charge that on or about September 29, 2024, in the city of Hudson, County of Lenawee, State of Michigan, that you did commit the offense of assault with a dangerous weapon?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
Yes,
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on record this morning, or that it was not your own choice to enter the plea?
yes, I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Burke to plead guilty today?
None, Your Honor.
Oh, yeah.
Mr. Burke, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes,
Mr. Casper, do you want to do the factual basis?
That would be fine, Your Honor. Mr. Burke, I apologize, Your Honor. Actually, I would ask the court to do it. I would
Okay.
clean it up. I don't have the document.
Mr. Burke.
I can, Your Honor,
Go ahead.
if there's no objection.
No objection.
Okay. Mr. Burke, were you in the city of Hudson on September 29th, 2024?
yes, I was.
And at that time, did you come into contact with a William Feelhauer?
Yes, I did.
Okay. And when you came into contact with him, did you grab like a pickaxe or some sort of hammer out of your truck?
Tire hammer.
Okay. And
Yes,
and
Yes.
okay. And do you agree that you use that as a weapon?
yes,
And you came towards Mr. Feelhauer with that, like to his face in an assaultive or threatening manner?
I believe
Did
that's
he-
sufficient.
I didn't hear him say yes. I'm sorry.
yes, I'm sorry, yes.
Okay. All right. I am satisfied with the factual basis.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Castleberry has. All right. I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Burke has had full knowledge of his rights and he's had competent counsel. Court has not made any agreement regarding the possibility of plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've set it forth on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for March 13th at 8:15 a.m.
Or does he need to report to probation this morning?
Yes, so if you'll just step across the hall, they will collect your information, Mr. Burke, and they'll give you a pack of information.
Thank you.
Thank you, Your Honor.
You're also going to do, Mr. Burke, a pre-sentence investigation interview with the probation officer. When you do that interview, please be truthful about the offense and about your background. Ms. Walsh, do you need anything else from Mr. Burke at this time, or can you just step over to the probation department?
You can just step on over. Thank you.
Okay, so you go straight across the hall there to probation.
Great, thank you, sir.
Okay, and then Mr. Sarin is your. Yes. This is file 24-21898-FH, People versus Larry Preston. Oh, wrong. All right, this is file 25-22112-FH, People versus Brody Raymond Sarin. We are here today for an arraignment in this case, and we are proceeding today partially by Zoom and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
P.B. McClure, on behalf of the people.
Bert Castleberry, on behalf of the defendant.
And sir, you're Brody Raymond Sarin. Yes. Mr. Castleberry, does Mr. Sarin wish to have the information read today?
Oh, Your Honor, we waive the reading.
Okay. Have you received copies of the prosecutor's witness list and request for discovery?
I have, Your Honor.
And how does your client wish to proceed today?
Your Honor, we would enter a plea of not guilty and request a retrial.
Enter a not guilty plea for Mr. Sarin and set a pretrial for March 5th, if that date works.
March 5th at 8:15.
March 5th at 8:15.
Correct, Your Honor.
All right. Anything else we need to address with this case today?
No, Your Honor.
No, Your Honor, thank you.
Thank you very much then. Ms. Dumont, are you ready to proceed with rule versus rule?
Yes, Your Honor.
Okay, this is file 24-51568-PH, Christine Ann Rule versus Karen Mary Rule. We are here today for hearing on order to show cause. We are proceeding today in person. Ma'am, you are Christine Rule.
Yes, sir.
And Ms. Dumont, do you want to place your appearance on the record?
Katerina Dumont for Karen Rule.
And ma'am, you are Karen Rule. I need you to speak a little louder than that.
Sorry. Yes.
Ms. Rule, you're before the court today on an order to show cause. That show cause alleges that you violated a personal protection order by tagging the petitioner in Facebook posts. Do you understand that the maximum penalty for violation of a personal protection order is up to 93 days in jail and or a $500 fine?
Yes.
You have the right to be represented by an attorney at this and any other hearings we have on this matter. If you can't afford an attorney, the court would appoint one for you at public expense. Obviously, Ms. Dumont is here and representing you today. Ms. Dumont, do you know how Ms. Rule wants to proceed today?
Your Honor, if we could get another pretrial date, this offense occurred before the last hearing we had with the previous violation of the PPO. So one was alleged to occur October 10th and one was alleged to occur October 20th. And then I have reached out to Ms. Christine Rule to get documentation, screenshots of the Facebook post. So I did receive the documents that my client had, but I have not seen screenshots that were referenced in the police report.
Okay, so I'll enter a not guilty plea for Ms. Rule. We can set it for a pretrial on February 12th at 8:15 a.m. And all parties can attend that either in person as you've done today or by Zoom.
Thank you.
Is there anything else we need to address today?
No, Your Honor. Thank you.
Okay, if you need Zoom information, the bailiff has that.
Thank you.
All right, thank you. Okay, Mr. Mawad, I do have Mr. Sherwood here.
Yeah, Judge, we have two, Sherwood and Gargan.
Okay, Mr. Gargan is here on Zoom and so is Mr. Sherwood. So
They're both pleased, Judge, and I do not need to talk with them.
okay. Mr. Gargan logged in first, so let's do Mr. Gargan first.
Okay. Phoebe, let me find out if he can get a check by tomorrow from what he has already, the 20, and go from there, okay? That could be part of his plea.
I think I indicated on the plea form. Let me see what I put. Before or on the sentencing date.
Yeah, okay. I'm gonna recommend that he.
But the
does
sooner the
tomorrow.
better.
No, I know. Okay, I'll tell him that.
Okay, Mr. Gargan, if you are there, I'm going to send you a request to start your video.
I'm here, sir. There we go. Sorry about
All
that.
right. Okay, so this is file 24-21979-FH, People versus Paul Anthony Gargan Jr. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, going to have the attorneys place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Your Honor, good morning. Elias Muwad appearing on behalf of Mr. Paul Anthony Gargan.
All right, and sir, you are Paul Anthony Gargan Jr., is that correct?
Yes, sir.
Okay. Mr. Muwad, Mr. Gargan is intending to enter a plea today, is that correct?
Yes, Judge, there was an amended information filed. Count 1, which is the felony, embezzlement, agent or trustee, 20,000 or more, but less than 50,000 is going to be dismissed. He is going to be pleading guilty to count 2, embezzlement, agent or trustee, $200 or more, but less than $1,000. And he has to pay back a total of a little over $41,000 for restitution, of which, Paul, how much do you have ready to give them? Real quick.
20,000.
$20,000 to be paid on before sentencing, but I'm going to recommend this week to pay that.
Okay, is that a complete and accurate statement of the plea agreement, Ms. McClure?
Yes, let me just read section 7 of the plea agreement. Must admit full amount of restitution and factual basis for the plea. Must have at least 21,000, but we're fine with 20,000 in restitution paid before or on the sentencing date, or the misdemeanor plea will be withdrawn and the felony charge will be reinstated, and must pay remaining restitution over the course of probation.
That is accurate, Your Honor.
Mr. Gargan, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
Mr. Gargan, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, embezzlement as an agent or trustee of $200 or more, but less than $1,000?
Yes, sir.
Are you satisfied with Mr. Muad and the advice that he's given?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine, or a fine of 3 times the amount embezzled, whichever is greater?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Muad?
Correct. That's correct.
Is that also your understanding, Mr. Gargan?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Gargan, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
How do you wish to plead to the charge that on or about July 2nd, 2022 through April 22nd, 2024, in the city of Adrian, County of Lenawee, State of Michigan, that you did commit the offense of embezzlement by an agent or trustee, $200 or more, but less than $1,000?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than a plea bargain to induce Mr. Gargan to plead guilty today?
None, Your Honor.
None, Your Honor.
Mr. Gargan, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty?
Yes.
Mr. Muad, do you want to review the factual basis?
I will. Paul, I'm going to be asking you some questions so the judge can accept your guilty plea. On or about July 2nd of 2022, to April 22nd, 2024 in the city of Adrian, county of Lenawee, did you, being an agent, servant, or employee of the Adrian Fire Department, Union Local 1511, convert to your own use the amount of $41,540.16?
Yes,
And that money did not belong to you, it belonged to the union, correct?
correct.
Mr. Gargan, can I ask you a few questions?
Absolutely.
Were you the treasurer of the union at that time?
I was.
And as treasurer, did they give you control of the money in the union account?
They did.
Okay, and through that control of the money, is how you converted it to your own use?
Yeah, I did, by a stupid mistake.
Paul, sorry, Judge. We talked about this. It's not a mistake. You have to say you knew what you were doing and that you stole the money. All right?
All right. Yes.
All right.
Okay. I'm satisfied with the factual basis.
I'm satisfied.
Okay, has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
You have, Judge.
Okay. I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Gargan has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the district court probation office for a pre-sentence investigation. And we will set sentencing for March 6th at 8:15 a.m.
Judge, if I can tell, Paul, do you have a pen and paper there at all? Okay, you'll remember this. That $20,000 is to be made into a cashier's check to the Adrian Firefighters Local 1511. Adrian Firefighters Local 1511 and hand delivered to the prosecutor's office at the courthouse.
Okay.
Okay? All right.
Okay, and Mr. Gargan, you'll also need to report to the district court probation office here at the Lenawee County Courthouse this coming Tuesday. So that will be February 4th at 8 a.m.
Okay.
And you're going to speak to Mr. McCarran.
Mr. McCarran?
Correct.
Okay. Thank you.
All right. Is there anything else we need to address with the case today, Ms. McClure?
No, thank you.
No, Your Honor. Sorry. No.
All right.
Thanks.
We are all
Thank
set.
you.
We're all set then, Mr. Gargan. You can go ahead and log out.
All right. Thank you, sir.
Okay. And did you have anything else, Mr. Moore?
Judge, sentencing or plea on Mr. Sherwood?
Okay.
Charles Thomas Sherwood?
Oh, that's right. I'm sorry.
It's okay. And that one's set for trial in March, so we'll get that off your calendar in March.
Okay, this is file 24-21855-FH People versus Charles Thomas Sherwood. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, may I have the people?
Your Honor, good morning. Elias Mawad appearing on behalf of Mr. Sherwood.
All right, and it's my understanding that Mr. Sherwood is going to enter a plea today.
That's correct, Judge. There is a plea agreement, and Ms. McClure, if I'm wrong, let me know. He's going to be pleading guilty to added count 3, child abuse, 3rd degree. The first 2 counts would be dismissed. The sentence agreement is to 30 days in the LCJ initially with credit for time served. And then we're going to have dismiss the remaining counts. And then the final provision, Judge, is that he can have contact with his own minor children and can be allowed to have that pursuant to any CPS/probate court order.
Okay, Ms. McClure, is that a complete and accurate statement of the plea?
It is.
Okay, Mr. Sherwood, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Charles Thomas Sherwood, correct?
Yes, sir.
Mr. Sherwood, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3 on the amended information, 3rd degree child abuse?
Yes.
Are you satisfied with Mr. Mawad and the advice that he's given you?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed on the record here today. Is that correct, Ms. McClure?
That's correct. I think the conversation we had with Your Honor about this case was that it would be 30 days initially, but he had about 15 days credit, so it'll be about 2 more weeks.
That's correct.
Is that also your understanding, Mr. Sherwood?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Sherwood, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal of the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
I do.
How do you wish to plead then to the charge that on or about May 13, 2024 in Rollin Township, Lenawee County, Michigan, that you did commit the offense of 3rd degree child abuse?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Sherwood to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Sherwood, other than as we've discussed on the record today, has your attorney promised you a particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Muad, do you want to cover the factual basis?
Sure. Charles, in order to accept the guilty plea, I have to ask you some questions. On May 13th, 2024, in Rowland Township, County of Lenawee, did you knowingly or intentionally cause physical harm to your child, the initials being K, and it's a hyphenated middle name, JV, last name Sherwood, by either hitting, punching, grabbing, and or pushing him on that
Yes.
day? And you did previously have a conviction for child abuse, 4th degree, in the 12th District Court on 10/24/2018, correct?
Yes.
Just two follow-up questions. One, do you agree that on that date and time that was not that physical contact with KS was not for reasonable parental discipline?
I'm sorry.
Do you agree it was not reasonable parental discipline?
Yes.
Okay, and that prior that you had from October 2018, that was for a child abuse 4th degree?
Yes.
Okay, I'm satisfied with the factual basis.
Me too, Judge.
Thank you. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr.
Yes,
Muad?
Your Honor. Yes, sir.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Sherwood has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as it's been discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for March 13th at 8:15 a.m.
I would just ask that that be in person, Judge.
Yeah, that's fine. Charles, the next date has to be in person because of the incarceration. They would take you from there. Okay.
Yep.
All right.
All right. Mr. Sherwood, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
All right.
And I'm going to put you in a breakout session right now with Ms. Walsh from the probation department so she can collect your contact information and give you some instructions about what to do next.
All right.
Mr. Muad, do you want to be a part of that breakout room?
No, I don't have to. I know Ms. Walsh for a long time. She doesn't bite, Charles.
Okay. All right. So, Mr. Sherwood, when you are done speaking to Ms. Walsh, you can go ahead and just leave the meeting.
All right. Thank you.
Thank you, everybody. Thank you.
Thank you.
Judge, is Mr. Daly there? I know he has to head out to Hillsdale shortly.
He was here just a moment ago and he stepped out.
Okay, I just want to make sure we can get to his case because that's another
Ms.
one that,
Lamont is here. She's going to step out and she can grab it.
He's on his way right
Okay, he is coming in the courtroom right now.
okay. The case we have with Mr. Daly is set for trial next week, and I think we have a resolution. So I just wanted to make sure we got it taken care of because of the trial.
Okay. Okay, Mr. Daly, are you ready on Mr. Smitty?
Ready, Your Honor.
is file 24-21898-FH, People versus Larry Preston Smitty. We are here today for a final pretrial conference in this case ahead of a trial date set for February 4th. We are proceeding partially by Zoom and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
E.B. McClure, map of the people.
James Daly has it.
Okay, and Mr. Daly, where do we stand with Mr. Smitty's case today?
Right now, we're prepared to go to trial on the 4th. There's been an attempt to resolve this matter. A resolution is still ongoing. It hasn't been reached yet. And so I can only assume it's not going to be reached and it's going to be a trial. If there is a resolution, we'll probably take it.
I'm sorry, I guess I thought we did have a resolution. What was? I don't know.
Okay, so Ms. McClure, what is there a current offer from the people?
Yes, it would be a plea to a, excuse me, I'm pulling up the amended information now. It would be a plea to a domestic violence second offense instead of a domestic violence third offense, and that any jail time would be deferred upon any violation.
You want to do that?
We would be asking for no drugs or alcohol conditions while on probation.
You want to do that?
Okay,
So we're prepared to plead then, yeah.
So Mr. Smitty does want to accept that offer.
He does.
Okay. Ms. McClure, I don't have an amended information. That doesn't mean you didn't send it, but do you have one you could send me?
I did not send it, but I'm sending it. I just sent it to you.
Okay.
Sorry about that.
Be on probation. Left on jail.
You want to you hand this to Mr. David, please. Thank you. Okay, so I've just had the bailiff hand Mr. Daly copy the amended information. So Mr. Smitty, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Sure.
And you are Larry Preston Smitty Jr.?
I'm Larry Preston Smitty, not Junior.
Not Junior?
My dad's Larry Jean. I'm Larry Preston.
Okay. Mr. Smitty, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, domestic violence, second offense?
Yes, Your Honor.
Are you satisfied with Mr. Daly and the advice that he's given?
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Ms. McClure?
That is correct.
Mr. Daly?
Yes, Your Honor.
Is that also your understanding, Mr. Smitty?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Smitty, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about June 17, 2024, in Madison Township, Lenawee County, Michigan, that you did commit the offense of domestic violence, second offense?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter that plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Smitty to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Smitty, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Daly, do you want to cover the factual basis?
Yes, Your Honor.
I would say I can, Judge. I don't know if he has the information in front of him or not.
I'm sorry.
Do you want me to, Jim? I don't know if you have the information.
I got the information right here.
Okay.
Okay. All right, on June 17th of 2024, were you with another individual?
Yes, sir.
And who was that?
Emily Woodruff.
Emily Woodruff, and you were in a dating relationship at the time?
Yes.
And at least one time, did you slap her or do something like that?
Yes.
Okay. That was a result of a disagreement, which you believe she started.
Yes.
But you know now that you can't have physical contact with somebody when they're having a verbal confrontation with you.
Yes.
Okay. And after she was struck, did you leave the property?
Yes.
Okay. I have no other questions. Banner.
Ms. McClure.
Mr. Smitty, was that in Madison Township?
In or around, yeah. Yes.
Okay. You were in a vehicle,
Yes.
but you agree you were in Lenawee County?
Yes.
Okay. And do you previously, or had you previously been convicted of a domestic violence on or about May 5th, 2017?
Yes.
Okay. I'm satisfied with the factual basis.
Has the court complied with MCR 6.302 BC and D, Ms. McClure?
It has.
Mr. Daly?
Yes, sir.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Smitty has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll refer this matter to the district. I'm sorry, to district court probation office for a pre-sentence investigation and set sentencing for March 7th at 8:15 a.m. So, Mr. Smitty, you will need to report to the district court probation office and see Mike McCarron in that office on Tuesday, this coming Tuesday, February 4th at 8 a.m.
Is that downstairs?
Downstairs on the first floor.
Bigger.
All right, so you're gonna do a pre-sentence investigation interview with him. When you do that interview, please be truthful about this offense and about your background.
It was March what, Your Honor?
So March 7th.
Thank you.
All right, anything else we need to address?
No, Your Honor.
All right, thank you, then we're all set.
Thank you, Your Honor.
Okay, Mr. Malero, are you ready to proceed with Mr. Satterla?
Your Honor, I would need to speak with him. I tried to talk to him yesterday and I couldn't get a phone connection or something.
Okay, and I'm sorry, the gentleman in the hoodie there, what's your name?
Mr. Walden or
Walden.
Yeah.
You're, okay. All right.
I need to speak with Mr. Walden as well, Your Honor.
Okay, so we will get the iPad set up in the hallway. Ms. McGrain, are you available to get the iPad turned on and connected?
Absolutely, Judge, on my way.
Thank you. So Mr. Satterla, if you'll just step out to the hallway, there's an iPad on a stand right outside the door. Someone will come out and get that hooked up and put you in a breakout session with Mr. Malero.
Your Honor, may I ask a question about something?
Go ahead.
Did we ever get Mr. Outley in from the federal court or federal prison? Harold Outley?
No, I do not have him here today. We do have a writ in the file for his appearance today, but they have not responded to it apparently.
Okay, thanks. Appreciate it.
I love you so much. All right, so you should be good to go. Sure.
Okay, Mr. Saddle, I'm gonna put you in a breakout room with Mr. Malero right now. Okay, Ms. Underwood, have you spoken to Mr. Till?
I have spoken with Mr. Till, Your Honor.
Okay, can we bring Mr. Till in?
I believe Ms. Meir is modifying a plea agreement.
Oh, okay, so we need a minute. We can wait on that,
Mr.
sorry.
McClure, excuse me.
Okay.
But we're ready whenever that comes.
Okay.
I believe we already have an amended information.
Sorry, Judge, I was briefly on the phone, but I heard you say Chad Till. I just forwarded Miss Underwood as well as I'm working on forwarding to the court an updated plea offer and amended information. So I think we should be ready on that.
Okay.
And I've already reviewed that with him, Your Honor, so he can sign that in here.
Okay.
Might have already sent the amended to the court a month ago, but I just sent it again just in case.
Thank you. This is file 24-220008-FH People versus Chad Till. We are here today for a pretrial conference in this case, and we are proceeding today by video conference, partially by video conference and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, may I have the people?
Rhonda Underwood on behalf of Mr. Till this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Till's case today?
Your Honor, at this time, through negotiations with the prosecutor's office, we have arrived at a plea agreement in this matter, Your Honor, whereby Mr. Till will plead guilty to count 2 of an amended information, Your Honor, prisoner possessing weapon attempt, a 2.5-year felony, count 1, and the habitual offender third habitual offender notice will be dismissed, Your Honor, and Mr. Till will receive the benefit, Your Honor, of there's an agreement that Mr. Till will be sentenced to the low end of the guidelines. And Mr. Till is aware that this is a sentence that must be served consecutively to the sentence he is serving now.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
All right, Mr. Till, would you raise your right hand? To the extent you can. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Chad Till?
Chad Till, yes, sir.
Mr. Till, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to attempted prisoner possession of a weapon?
To attempt, yes, sir.
Do you understand that the maximum possible penalty for that offense is 2.5 years in prison?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that, other than as we've discussed it on the record today, is that correct, Ms. McClure?
That's correct.
That is correct.
Ms. Underwood?
That is correct.
Is that also your understanding, Mr. Till?
Correct.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent at your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Till, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about December 18th, 2023, in Madison Township, Lenawee County, Michigan, that you did commit the offense of attempted prisoner possession of a weapon?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept the plea, you're giving up any, claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Till to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Till, other than as we've talked about it today, has your attorney promised you any particular sentence or estimated what it would be?
2.5, which recommended is a 30.
That's the maximum.
That's the maximum. And then there's 5 month, which would be the lowest they could go.
Okay.
I estimate.
Estimated.
So your attorney has talked to you about what she thinks the low end of the guidelines will be.
Yes.
Is that right? Do you understand that there's no guarantee that that's actually what it will be, that I have to make a determination about how the guidelines are scored? And so it could change between what she's told you and what it actually ends up being.
Yes, Your Honor.
And knowing that, do you still want to go forward with your plea?
Yes, Your Honor.
Okay. Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, do you want to review the factual basis?
Thank you, Your Honor. Mr. Till, let me take you back to 12/18/2023. Were you an inmate at the Gus Harrison facility located in Madison Township, County of Lenawee, State of Michigan?
Yes, ma'am.
And you were lawfully incarcerated there, correct?
Yes, ma'am.
And at that time, did you have under your control an implement which could be used to injure someone?
Yes, ma'am.
Or allow them to escape?
No.
Well, I mean, but it could be used for that.
Oh, yes, ma'am.
Okay. You were not using it for either of those things.
No, I was using it for self-harm.
Thank you. And it is illegal or not, you aren't allowed to have a weapon in prison. You know that.
Right.
Okay. I believe the facts have been established, Your Honor.
Ms. McClure, are the people satisfied with the factual basis?
We are, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Ms. Underwood?
It has.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Till has had full knowledge of his rights and he's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as we've discussed it on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for March 14th at 8:15 a.m.
Do you want to be sentenced in person or by Zoom?
In person.
Mr. Till would like an in-person sentencing, Your Honor.
Okay, so Mr. Till has requested to be here in person. That is his right. So Ms. McClure will need an in-person writ for the sentencing hearing.
And what was that date?
That was March 7th,
14th.
I'm sorry, March 14th at 8:15 a.m.
Okay.
March 14th. All right, so Mr. Kill, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background. Ms. Walsh, do you need any additional information from Mr. Till at this time?
No, thank you, Judge.
Okay. All right, so we are all set then. Thank you for your time. Okay, and then Ms. Underwood, Mr. Getz and Mr. McCollum Rosa are both here on Zoom.
Is Mr. Getz on here?
That is mine, Your Honor. Getz is mine.
Oh, I'm sorry. Okay, so Mr. McCollum Rosa is here. Do you want to go log in?
I will go log in, thank you.
Okay. Mr. Malero, are you ready to proceed with Mr. Satterla?
I am, Your Honor.
Okay, Mr. Satterla, you want to come forward, please?
Judge, I think your remaining cases are with other prosecutors, so I'm gonna go ahead and log out, but just have your office give me a call if something comes up.
Okay, thank you. This is file 24-22009-FH, People versus Arnett Satterla III. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready?
Good morning, Your Honor. Dave McCready for the people. Salvatore Malero on behalf of Arnett Satterla.
And sir, you are Arnett Satterla III?
Yes, sir.
All right, Mr. Malero, where do we stand with Mr. Satterla's case today?
Your Honor, I spoke with Mr. McCready yesterday and posited some options, and I just discussed those with Mr. Satterla. I don't think he's quite ready yet to enter a plea, so I'd ask if we could have a brief adjournment. I think he's going to come in tomorrow. We're going to sit down and see if we can't get this across the finish line on a plea. So that would be my request.
I have no objection to that.
And Your Honor, I did try to. We were playing phone tag yesterday, so I didn't get a chance to talk to him yesterday about it.
Okay. So I will adjourn this to February 12th at 8:15.
Okay, and Your Honor, if we get this to where it can be a plea, would the court be willing to take it in sooner than later?
Yes, if you find you reach an agreement, you're welcome to call the court, and if we have a place we can get you in, we'll certainly do that.
All right, thank you, Judge.
Okay, so February 12th at 8:15, Mr. Malero, would you do that stipulation in order for the adjournment?
Yes, I would.
And you can sign my name.
All right, so Mr. Sadler, your next date is February 12th at 8:15 a.m. You're all set for today.
Thank you, sir.
And Mr. Walden, if you want to step outside to the iPad, I'll put you in breakout room with Mr. Malero right now.
Thank you, Judge.
Okay, Mr. McCollum Rosa, are you there? Can you send your request to unmute? And Ms. Underwood, you need to speak to Mr. McCollum. I'm going to put you in a breakout session with Ms. Underwood if you give me just a second here. Good morning, Mr. Dagger Margosian. Who are you here for?
Morning, Your Honor. There was a case originally assigned to Judge Anzalone, but when reviewing the information just a moment ago, she realized there's a disqualification, so they're transferring that case down here.
Okay.
And the name is Timothy Merritt. Just
I'm sorry, I didn't catch the last name.
Merritt.
All right.
Thank you.
You just got the file. Is he on Zoom or how is he participating?
He's in jail. I think they're zooming him in now.
Oh, okay. And is this an arraignment or pretrial or?
It's an arraignment, yeah.
Okay. Sir, you are Mr. Merritt?
Yes, sir.
Okay, and let's see, do we have a prosecutor that's available to handle this?
Yes, Your Honor, I apologize.
Thank you. Okay. This is file 25-22113-FC, People versus Timothy Joe Merritt Jr. We are here today for arraignment in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Your Honor, Michael Dagger Margosian for Mr. Merritt.
And sir, you are Timothy Joe Merritt Jr.?
Yes, sir.
Mr. Dagger Margosian, does Mr. Merritt wish to have the information read today?
No, Your Honor.
Have you received copies of the prosecutor's witness list and request for discovery?
Yes, Your Honor.
How does Mr. Merritt wish to proceed today?
Your Honor, I'll be filing a motion to quash on this. I'm going to put in the request for the transcript of the preliminary exam that was held in district court. So ultimately for today, I'd like to just get a pretrial date that would meet those timelines.
All right, so I'll enter a not guilty plea for Mr. Merritt, and we'll set a pretrial. And Mr. Dagger Margosian, I'm not familiar at the moment with what transcripts are running from the district court. How much time do you think you need?
Well, I think it probably can be done in about 60 days. But I know that sometimes it takes up to 90. So I guess I'd be asking for a pretrial of 60 days from this point.
Okay.
And if we get the transcript before that, and if the motion is filed before that, we can be heard before that date, I guess.
Okay, so that's going to be the end of March. I don't have the last Wednesday in March available, but the first Wednesday in April would be April 2nd.
Yeah, Yeah, that's fine with me.
So April 2nd at 8:15 a.m. Is there anything else we need to address today?
Not from the people's standpoint, Your Honor.
Nothing on record, but I would like to, after this, I would just like to be in a breakout room with Mr. Merritt, if that's okay.
Okay. All right, we can conclude the hearing then, and I will transfer Mr. Dagomorgosian and Mr. Merritt to a breakout room right now.
Okay.
Close that out and set it up once more. Okay, Mr. Merritt, are you able to hear me?
Yes.
Okay, I apologize for the confusion. Let me try this once more.
Huh? I said I put me in the wrong room.
Okay, Mr. Malero, are you ready to proceed with Mr. Walden?
I am, Your Honor.
Okay, Mr. Walden, can you come forward to the podium, please? This is file 24-22057-F. People versus Andrew Joseph Walden. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Benedetto.
Alex Bayonetto for the people.
Salvatore Malero on behalf of Andrew Walden.
And sir, you're Andrew Joseph Walden?
Yes, sir.
And Mr. Walden is present here in the courtroom in person. Mr. Malero, where do we stand with Mr. Walden's case today?
Your Honor, asking for, again, a brief adjournment. Mr. Bayonetto has tendered a plea offer that is tethered to a district court case. And it pains me to admit that it's a pretty reasonable offer, but I'm not privy to the district court case, so I need to review that with his attorney in our office on that. I think once that's finalized, we would have a resolution. So that's the basis for my request.
Okay, Mr. Benedetto, anything you need to address from the people's side?
No, Your Honor.
All right, let's go. Is February 19th All right, Mr. Malero.
That's fine, Judge.
So February 19th at 8:15 a.m.
Actually, Judge, his district case is the 27th. Is it possible to do it the following week?
So the next
26th?
week will be March 5th.
Oh, let's do the 19th then. Nineteenth is fine.
Okay, so the 19th at 8:15. Mr. Malero, would you do that stipulation in order for adjournment?
Yes, I will, Your Honor.
Okay. So, Mr. Walden, your next date is February 19th at 8:15. You can come in person as you did today, or if you prefer to attend by Zoom, you can do it that way.
Okay.
Okay, sir. Thank you. And, okay, Mr. Malero, are you going to need to speak to Mr. Getz?
I do, Judge, real quick, and then I'm thinking I might actually get a plea on this one.
Okay, let me set that up. I apologize,
You may have finished up.
Mr. Dagger Margosian, I clicked the wrong button and closed all the breakout rooms. I can put you back in with Mr. Meredith. Give me just a moment.
Judge, that's okay. We'll be, thank you.
Okay. If that's the case, then Mr. Merritt, you can let the officer with you know that you're all set with court.
You hear that? It sounded highly unprofessional. You're not.
All right, Mr. McCollum, Rosa, I need you to start your video again and unmute your device. Okay, so we are on the record in files 24-21958-FH and 24-22070-FH, People versus Skylar, Austin, McCollum, Rosa. We are here today for a pretrial conference in each of those cases, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Rhonda Wood for Mr. Rosa, Your Honor. Are we off the live stream, Your Honor?
No, that is still going. Is there some reason we need to stop it?
Could I request that it be turned off, please?